Okay, welcome, Professor Josh Bentley from TCU University, my friend and colleague. How are you doing today, Josh?
I'm great, Guy. How are you?
Thank you so much for coming in today. We are talking about legal considerations for folks who are going into the field of strategic communication, those who are going to be brand managers, social media managers, anybody working with social media, and you are an expert in the field. So thank you so much for coming in today. Josh, if somebody is about to enter the field, what are some of the key topics that he or she may want to consider in order to succeed
Sure.
in the work?
I think because there's so much stuff that is easily available on the internet, people sometimes think, well, I can kind of do whatever I want on the internet. I can take a photo from here and use it, or I can post my opinion. I could do anything, and it's all just free and easy. But it's not quite that simple. There are copyright issues that people on social media have to think about. There are issues related to privacy rights and publicity rights. There are issues related to defamation, hurting somebody else's reputation. And there are issues, if you're in strategic communication, that have to do with false advertising, disclosing things for social media influencers. So there's actually quite a bit to consider.
Right. Well, let's unpack these one by one. Where shall we start?
Let's start with copyright, because everybody's heard of copyright, but Google image searches make it so easy to go find stuff. And sometimes you just find the perfect thing out there. And you're like, well, surely I can use it. Somebody has posted it online. And it's not that simple. So under federal law, as soon as you create something, whether it's an image or something you wrote, whatever, you have a copyright in it. Now, you can't technically sue someone for copyright infringement until you register your copyright with the US Copyright Office. But if somebody else starts using your content, you can go register your content and then file a lawsuit against them. And even if they take your content down after you complain about it, theoretically, you can still sue them for the amount of time that they had your content posted on their website or on their social media page or whatever. So my advice is always to content creators, create your own content, because then you have the copyright in it. And if you do that, make sure you put a little copyright notice on there. You're not legally required to do that, but that helps you prove that you're the copyright holder if someone else tries to steal and use your stuff. Now, you don't always have time to create your own content, and you can use content that is in the public domain or that is licensed under a Creative Commons license. If people go to creativecommons.org, you can read about that. There are websites like pexels.com where people have given permission to have their photography used for free, and it's okay to use that kind of stuff, but we shouldn't assume that just because something is out there on the internet, that means it's in the public domain. It's probably not that way.
There are exceptions, right?
So fair use is an exception. Educators often use things for educational purposes that are copyrighted. If you want to criticize or critique something, it's okay to use little bits and pieces of it. For example, if you have a YouTube channel and you want to do a movie review, it's okay for you to show some clips of that movie and comment on that movie, because that doesn't take the place of people actually watching the movie. But if you tried to show the whole movie and then talk about it, that would be not fair use. That would be copyright infringement. So fair use is actually kind of complicated. It has to be done. You have to use somebody else's work to create something new and in a way that won't replace that original work. But yes, that's an exception.
Fantastic. Let's move on to the next one.
Sure. So privacy is obviously a big concern for everybody. People, even though people go on social media and share what they have for breakfast, lunch, and dinner, people still want to have their privacy, and there are laws that protect that privacy. These are usually state laws, so they might vary a little bit, but somebody could sue you for something called publication of private facts. If you post something on social media about a private person and it's not newsworthy, and the information you posted about them would be highly offensive to a reasonable person, they can sue you for that. So for example, posting about a medical condition that somebody had that's not part of the news, they could easily sue you and win over that. So just think twice before posting private information about anyone. And if there's any doubt, check with them first. And of course, there are also specific federal laws like HIPAA that regulates the privacy of people's medical records, or FERPA that controls the privacy of educational records. And so if you were involved in social media for a hospital, you'd want to make sure that all of your employees know not to post something that might disclose private medical information about a patient. If you work for a school or a university, make sure that all your employees know, never post something that might reveal somebody's grades or other educational records. Those are all related to privacy.
Okay. The expectation of privacy, most undergraduate students use social media platforms. Is there a real expectation of privacy in today's world?
No, I mean, practically speaking, if you post something about yourself, it's out there forever. You can't take it back. You could delete a post, but somebody might have screenshotted it and you can't come back later. If you've disclosed something about yourself, you can't say later, oh no, that was private. I'm sorry, it's not private anymore. There are places like in Europe where they have right to be forgotten laws, where you can actually ask Google or some other platform to take down information, but we don't have that in the United States. So anything you post is fair game forever for other people to talk about. So that's important to be aware of.
That's important to know that a lot of the regulation about the internet was legislated decades ago before the, many of these platforms came about. All right, let's move on to the next one, Josh.
Well, related to privacy is also the concept of publicity rights. And again, these are state laws, but virtually all states have some kind of protection for this. The point of a publicity rights law is that a social media company or any brand cannot take content that I have created and use it in an advertisement without my permission. Obviously, people can retweet things that I tweet and so forth, but if I post a picture of myself wearing a certain pair of headphones, that headphone brand cannot take that picture and put it on their website or put it in their social media in a way that would make it seem like maybe I was doing an endorsement for them. I have a right to control how my publicity is used for commercial purposes. A news outlet could do it, but a brand advertising could not do it. And so all that means is if there's user-generated content out there, maybe it's an image, maybe it's a positive review, and a brand would like to use that in some sort of promotional way, they just have to get permission first. And lots of brands do this by reaching out to people and saying, hey, if you would allow us to use this image or the content you wrote in our marketing, please reply with a certain hashtag. And as long as they can document that that user who created the content has given them permission, then they're in the clear. But if they don't have that, they should leave that content alone.
Well, this really brings us to the next one, which is disclosure. Let's talk about creators and influencers and what are some of the legal expectations from them?
Right. So there's lots of people that are making a good living for themselves as social media influencers. They're on Instagram, they're on YouTube, they're all over the place. And it's really valuable because they have a strong connection to their audience and people trust their opinions. So brands will send them products to try out. Brands will pay them to create posts about their products. And the Federal Trade Commission has regulations about this. And the main one is, there's two really. The main one is an endorsement has to be genuine. So someone cannot pretend to use a product and say that they like it. If they get caught, they could get fined or in trouble with the FTC. And if a brand is participating in this knowingly, they could get in trouble because of what their influencers have done. And the other thing is that they have to disclose if they're getting products for free or if they're getting paid or something like that. So if you're making a video and you've got a product for free, you should let people know that. And you should do it in a way where normal people will notice. So you should probably mention it at the beginning of the video. Maybe you should mention it at the end of the video, just so that if the FTC watches that video, they will feel like you properly disclose that you got something for free. If you're getting paid, you should disclose that as well. A lot of times Instagram posts will have hashtag ad at the beginning. And the FTC is pretty particular about this. You have to put it near the beginning where people are going to see it. And you're not supposed to bury it at the end with a bunch of other hashtags where people are likely to miss it, because this is important information for the audience to know as they evaluate the credibility of what social media influencers are telling them.
This is a real issue. I mean, for both influencer marketing, native advertising, there are so many different labels, right? Promoted by, partnership with, it's so confusing for people out there. But nevertheless, you as a content creator or as a marketer have to be aware of the regulation.
Right. And as long as you can make a strong argument, it doesn't matter necessarily if you use hashtag ad or hashtag promoted, you have to be able to make a strong argument to the FTC that you did disclose, and they'll probably accept that.
Okay, fantastic. We have one more, right?
Yeah, I still wanted to mention, well, actually, two more things briefly. One is also related to the FTC, and that's false advertising. So the definition of false advertising for the Federal Trade Commission is a material representation, omission, or practice likely to mislead a reasonable consumer. So this means, of course, if you put something in an ad that's false advertising. But if you leave out something that's really important to understanding what your product can do or what kind of deal you're offering or whatever, that could also be misleading. And sometimes companies create copy or other promotional material, and it was created for a website, and then they need to shorten it, condense it for social media because of character limits or other things, and they might leave stuff out. And they just have to be careful that whatever they leave out is not material, meaning it's not something that people would base their decision on. They don't leave out any really important information when you're condensing your content on social media, because that could cross the line into false advertising. And then the last thing I was just going to mention is defamation. And there's nothing special about defamation on social media versus other media, but defamation is just lying about someone in a way that damages that person's reputation. And sometimes on social media, people get a little aggressive. Usually good brand managers don't, but there could be a temptation. And if you say something about a person that is false and that hurts their reputation, they can sue you. So think twice before criticizing someone. You would not normally be held liable for retweeting something that was considered defamatory, but if you create the content online, then you could be held liable, and you just want to stay clear of that.
Excellent advice. And what I'm gathering from all this is, besides taking classes such as yours, media law, which are offered in most universities, employers who are thinking about hiring somebody to run their social media should actually spend a day and offer training about some of the key legal considerations for social media managers.
Yeah, because if you hire someone to run social media for your brand and they do make a mistake, that will blow back on the whole brand. The company will be liable if something was done that was illegal, not just the individual employee. And so absolutely, it's in the company's interest to make sure that everybody working on that knows what the rules are.
Okay. Fantastic. Any other piece of advice before we say goodbye today?
Well, my general advice to someone who's new in a field is don't be afraid to ask questions, right? Sometimes these legal issues are complicated. Don't just assume that you know and you can roll the dice and take a chance. If you need to, sometimes a quick Google search is all it takes to find the answer to a question and save yourself a lot of trouble.
Or a video like this one. So thank you very much for joining us today, Professor Josh Bentley from Texas Christian University, and have a wonderful day. We appreciate your advice.
Thanks so much.
Bye-bye.